I'm going to go through my decisions on the 4 pending motions. Analyzing whether anything from the May 6, 2019 case is admissible. The medical examiner has opined that the cause of death was cardiopulmonary arrest, complicating law enforcement subdual, restraint, and neck compression. The defense theory of the case being that it is due in part to drug toxicity and not to positional asphyxia or other causes. The state and its experts opine otherwise, saying that it is positional asphyxia and the restraint that was placed on George Floyd by the defendant. Clearly there's a cause of death issue here. On May 25th, 2020, the date of Mr. Floyd's death, there is a very similar starting situation as on May 6, 2019. That is, an officer approaches him while he's seated in a car. He is at gunpoint. The police have a gun pointed at him. And the May 25th, 2020 was Officer Lane. They both holster their guns at some point, but there is a shocking interaction between the police and Mr. Floyd. Shocking to Mr. Floyd. That is fairly clear. There is also evidence of drug concealment upon being stopped by the police. Basically concealment by ingestion. So how is May 6th, 2019 relevant to that? Well, there are certain things that are not relevant. Mr. Floyd's emotional behavior is not relevant to cause of death once he is pulled out of the squad car. Generally, what he is saying up until the time he talks to a paramedic is not admissible. Nor the fact that the officers said this was part of a narcotics investigation and they suspected Mr. Floyd of dealing drugs. Not relevant. Not admissible. But as to the point of cause of death and medical condition, May 6th is relevant. There is a modus operandi to conceal drugs in part by ingesting them, but also doing so in a very stressful circumstance. That is, being pulled out of a car at gunpoint and handcuffed. What I'm going to allow is a portion of the videotape of the one officer from the time he approaches the car until Mr. Floyd is out of the car and handcuffed. The whole point here is we have medical evidence on what happens when Mr. Floyd is faced with virtually the same situation. Confrontation by police at gunpoint, followed by a rapid ingestion of some drugs. We don't know exactly how many, but there was an admission that he had done it at the time of the stop. Now, as to the motions for continuance and for change of venue. The purpose of a change of venue is to ensure that the defendant has a fair trial by an impartial jury. The same is true as the basis for the defense's latest motion to continue, with the hope that as time passes, people forget some of the pretrial publicity. Unfortunately, I think the pretrial publicity in this case will continue no matter how long we continue it. And as far as change of venue, I do not think that that would give the defendant any kind of a fair trial beyond what we are doing here today. I don't think there's any place in the state of Minnesota that has not been subjected to extreme amounts of publicity on this case.